So back in 1965, Congress passed the Voting Rights Act of 1965, which included provisions that required federal oversight when states wanted to make changes in who could vote, how people voted, things having to do with voting, drawing congressional districts, gerrymandering, all these kinds of things that might have a racial impact. It was a wise piece of legislation, an important piece of legislation, and it got blown up 10 years ago this week by 5 Republicans on the U.S. Supreme Court in the case called Shelby County v. Holder. Kathay Feng is with us, the National Redistricting Director of Common Cause. CommonCause.org is the website. Kathay, Kathayccc is Kathay Feng's Twitter handle. Kathay, welcome to the program. Tell us about well, let's start with the Voting Rights Act of 1965, the provisions that got blown up by the Supreme Court when John Roberts essentially said there's no more racism in America.
Yeah, well, it's a pretty incredible decision, considering that even today we see example after example of discrimination at the polls, intentional and effect of laws that have been passed that restrict voting ability of minority communities. But what happened in 2013, 10 years ago, was we had the Voting Rights Act that had multiple types of protections. And the way that I like to simplify it is to think of it as you had a fire alarm that detected and allowed you to respond to smoke before the fire happened. That was Section 4 and 5. You had a fire extinguisher. If the fire happens, we can put it out. And then you have the fire department. Sometimes that was the courts. Sometimes it was the Department of Justice. And what essentially the Shelby County versus Holder did was it said, let's get rid of the fire alarm. So even if you have evidence that there is going to be a disparate impact because of a law that's just been adopted, you cannot stop it from going into effect. And taking away that protection before the harm has happened is what Shelby County did. So now what we have is you've got to let the fire happen before you can go in to extinguish it. And in a very dangerous case that's before the Supreme Court this term, Moore v. Harper, there's a possibility that the court could say, we don't even want the fire department to exist. So the very entities that might come in the instance of a finding that there is discrimination in the laws, now no longer can correct that problem through proactive or reactive actions.
Now, John Roberts and Antonin Scalia and Clarence Thomas and their buddies on the court didn't just come out and say, hey, we're all in favor of white supremacy in America. And, the states that are governed by a political party or by, individual governors and legislators who also are all in favor of white supremacy are just fine. We're just happy with that. What possible rationalization did Roberts and crew use to blow this up?
A piece of this is to say that Congress in 1965, when they adopted the Voting Rights Act, had extensive hearings to identify problems that had existed in states where states had consistently and historically adopted laws that discriminated against voters of color. And prevented them from being able to exercise their vote in a way that was meaningful, where their votes would count just like their white counterparts in that state. And so they sort of put those states on a bad behavior list. Mm-hmm. And they said, we're going to pay closer attention to everything that those states do. And if there is any indication that they are once again adopting laws that would restrict the ability of voters of color to be able to cast a meaningful ballot, then we're going to allow courts to step in and block those voting laws from happening. What Roberts and his court said was, even though Congress had, through bipartisan votes, readopted the Voting Rights Act again and again over multiple decades and consistently had hearings that said we still do face discrimination at the polls, they wanted to believe, and I think that they used the election of President Obama as their justification, that we are in a post-racial era. If we can elect a Black president to office, it must mean that we are past the racism that is built into our institutions and our systems. And so they justified it by saying there's insufficient evidence to keep holding these states that have been historically found to have committed racial discrimination when it comes to voting laws, hold them accountable in that proactive way. And we see even now in states like Texas, Florida, North Carolina, every chance that they get, they will adopt laws that disparately harm voters of color. So it isn't a past thing, but I think it is an attempt by the court to say that we're past racial discrimination and essentially become an activist court in obliterating a law that had been adopted by Congress in a bipartisan manner.
Can you identify specific harms that this decision 10 years ago by these Republicans on the Supreme Court have caused?
Sure. Well, the lead up to that 2013 case was incredibly important because people remember the context, right? In 2008, President Obama was elected, and then a whole slew of states started adopting restrictive voting laws that tried to eliminate the ability for nonprofit groups to get out there and register people to vote, like League of Women Voters, right? That restricted the ability for people to vote if they couldn't show a certain kind of identification. So in Texas, for instance, if you had a gun owner's permit, that was allowed, but if you had a identification that had been issued by the University of Texas, UT Austin, that was not allowed, right? So clearly it was balanced towards one kind of voter over another in a very partisan way. And those kind of voter restrictions were held in abeyance in 2012 when the Voting Rights Act was still going strong. And after 2013, when the Supreme Court obliterated Section 4 and 5, the fire alarm, right, of the Voting Rights Act, those laws were allowed to go into effect. And so we saw in 2014 the restrictions that really turned away thousands and thousands of voters because they couldn't jump through all the hurdles that had been newly put into place by the states that didn't want them voting.
So I realize the For the People Act, H.R. 1, would have addressed many of these issues. Is there, correct me if I'm wrong on that, but I believe that to be the case. Is there, I'm assuming Congress, at least Democrats in Congress are going to continue trying to fight that fight. Are there other battles? I know that you guys are also non-state respondents and more v. Harper. I don't know how that ties into this. Can you tell me about that?
Sure. Multiple ways that we can respond. So obviously Congress has two bills before it. One of them is right behind me, the John Lewis Voting Rights Act reenactment, right? But also the what is now called the Freedom to Vote Act. Both of those would protect, update, modernize our voting rights laws to ensure that people have the ability to cast ballots in a way that is current to 2023, right? So people are busy and sometimes you need to have options to vote, and walking to a polling place is not the only way that people can now vote. They can vote by mail. They can cast a ballot, in early days before leading up to Election Day. So protecting the ability for people to have an accessible right to the ballot is important. And that's what this combination of bills would do. But the other thing that we can do is fight it in the courts. And so in Moore v. Harper, this is a case that comes out of North Carolina, which has always been ground zero for redistricting battles. We've seen a lot of past examples of the lines being drawn to gerrymander to hurt Black communities, right? And certainly to gain a party advantage for the majority party. And in this instance, the state Supreme Court said that their state constitution protected against both racial discrimination as well as partisan gerrymandering. And so they ordered new lines to be drawn. Those new lines were drawn. And the state legislature kind of had a toddler's fit and went to the Supreme Court and said, not only was the state Supreme Court wrong, but they shouldn't even be allowed to correct their actions in in court. So they're wanting to take away, as I said before, the ability of a fire department to be able to respond to the fire. They want to take away the judicial branch out of the process of redistricting and out of the process of reviewing any legislative action when it comes to making federal election laws.
So, wow, that's remarkable. So, I guess, you know, we just need to get in line here with commoncause.org. You guys are fighting this, so people can go to commoncause.org and get more information. Kathay Feng, thank you so much for dropping by and sharing all this information with us. Very much appreciate it.
Thanks for having me and covering all of these important issues for your viewers to learn more.
Yeah, my pleasure. This is really important stuff. This is critical to the future of our democracy. Kathay, thank you. commoncause.org.